Mochi Health is here to help you start your weight loss journey with caring, personalized support. Meet one-on-one with board-certified obesity doctors and registered dietitians who truly listen and understand your unique needs. Eligible patients can access affordable GLP-1 medications delivered right to their door each month. No insurance? No problem. Mochi Health accepts FSA and HSA, making care accessible and affordable. And with 24/7 customer service, you'll never feel alone on your path to better health. Get started with Mochi Health today. Take the free quiz at joinmochi.com and use code AUDIO40 at checkout for $40 off your first month of membership. That's joinmochi.com with promo code AUDIO40.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my credible co-host, Brett.
Oh, yeah. There you go. Went with the positive. Could have gone negative.
I went with the positive.
You went with the positive. I appreciate that.
And for those of us who have been binge watching the Murdaugh evidentiary hearing today, know what I'm talking about. But if you don't worry. We'll talk you through everything that happened regarding today's hearing as to whether the jurors had been tampered with and whether Mr. Murdaugh gets a new trial. And you might just have to wait to the very end to understand why I called Brett credible.
I tell you what, the last two hearings we've had have had surprisingly quick decisions. I will say I predicted that this 3-day evidentiary hearing would last one day, and it did. I did not predict that the ruling would come at the conclusion of that one day.
Mere seconds after. Yes. I was tied up, doing my day job all day today. And I was like, it's okay. The hearing will go long. I'll tune in. And as I was going to tune in was when the opinion was being read. And I was like, wait, how is the opinion being read? Am I a day off? I thought it was a day off. But in fact, it was a very quick ruling. It was televised. And instead of making these nice people wait, let's just dive in. So as you guys know, Alec Murdaugh was convicted after a very lengthy trial about a year ago of murdering his son and his wife. And it was a very public trial. A lot of people watched it. We covered it. And then there was a bit of a bombshell fall of last year. So about less than a year after he was convicted, there was this filing from his defense counsel saying that there were allegations that the clerk of the court had tampered with the jury. And those of you who have been following us know that if you tamper with the jury and it affects the jurors' vote to convict, that is a massive, massive problem and could mean that Alec Murdaugh gets a new trial. And so today's hearing was about whether that very question, had the jurors been tampered with in a way that affected their vote to convict Alec Murdaugh. And if the answer was yes, potentially, that could mean that there would be a new trial for Alec Murdaugh.
And let me say this. We talked about this some in our last legal briefs on this, but for those of you just now joining us, as we said before, in so many ways, the standard that you apply is going to decide a case for you. And the defense argued and will argue on appeal. Now let's talk about appeal real quick. So this decision we're going to talk about will be appealed. When a decision is appealed, there's a legal question and a factual question. The legal question is, what legal standard should you apply? How do you review this? What are you weighing? What is the balance? That's the legal question. That has something called de novo review, and that means they start over. So basically, the appellate court gives no deference to the trial court. Whatever they said, doesn't matter. We're going to look at it anew. On factual questions, factual determinations, questions of credibility, those are ruled based on something called clear error, which is, did the judge clearly err in whatever conclusion they reached on a factual question? This is called a mixed standard of law. So you have de novo for the law, clear error for the facts. And that's what's going to happen once it goes on appeal. And people are going to look at this evidentiary hearing and they're going to decide, did the judge apply the right standard? And if they did, were the factual decisions they made clearly erroneous? If they weren't, and the correct standard was applied, then this is going to stand. The standard in this case, the defense wanted a standard that was essentially a structural error type standard. As we've said before, those are incredibly rare. Very rare that you have those, because we recognize that courts and court decisions, the judicial system is made up of people. People make mistakes. People do stupid things. People do bad things. We're not going to overturn every conviction just because someone does a bad thing or makes a mistake. But when you have a structural error, basically you say, look, that is such a bad mistake. That is such an error. It goes to such the heart of the matter that it doesn't matter whether or not you can show prejudice, whether you can show it affected the verdict. We're going to do it over. Like there's like a handful of things that have this, very limited number of things that have structural error. That's what the defense wanted, though. The defense basically wanted, if Becky Hill said anything to any juror that was improper, new trial. Doesn't matter if that juror said, I just thought she was some crazy lady, didn't even know who she was, didn't even realize she was a clerk of court. I decided it based on the fact that I heard a video of him there 20 seconds before his family was killed. So I thought, oh, he's guilty. Wouldn't matter if it's a structural error. Still got to do the whole trial again. That's what the defense wanted. The prosecution argued for a prejudice standard, which is much more common. And that has a 2-part test, or maybe a 3-part test, depending on how you think about it. First part, did it happen? Did she say it? Did she say something she shouldn't say? Second part, if she did it prejudice the verdict? And I think the way she's applying prejudice is not only did it affect the juror in some way, did it affect them in such a significant way as to undermine your confidence in the verdict, because the effect was so great that the strength of the case was not sufficient to overcome it. So you sort of have to weigh both those things. How great was the effect? How strong was the evidence? Compare those two together. If the effect was great and the evidence wasn't, that's going to be the kind of situation in which you're going to reverse things. That was the standard she was going to apply. And that was already a really hard standard from the very beginning for the defense. And they, at the very early on, objected once again to that standard and asked for that structural error standard. And the judge was basically like, not going to happen.
Absolutely. Great breakdown of the standards at play here. And something Brett said, I think, is very important here. The prejudice standard is much more common in this situation. Very, very few things are structural errors. So with all this in mind, and remember, there had been a hearing, a preliminary hearing, kind of deciding who was going to testify and also what the standard was. So we knew what the standard was going into today. And what we knew going into today was that this was not going to be a circus. The judge ruled that she was going to question the jurors, and she was going to rename them as well. So, A through Z, as opposed to their numbers before, just in case people could kind of manufacture backwards who these jurors were to preserve their anonymity. And that she would do the questioning, because essentially, if that is the standard, there are very few things that she has to ask, basically like 4 questions, instead of, for example, letting the defense counsel, Harpootlian in particular, go back and forth and drag this out into all of their thinking within the black box of the jury. We talked about why that it doesn't serve any interest here, especially when there's just a legal standard they have to make. And that's what she did today. She questioned each of the jurors herself and reported back, what she heard. And you could hear it. You just couldn't, the camera did not pan over the jurors. And then the only other person we knew going into today who was going to testify was Becky Hill, who is, of course, at the center of all these allegations that the defense has put forward as a potential tamperer of the jury. She is the clerk of court.
One thing I thought was funny, so they did all this to preserve the anonymity of the jurors. And then at some point, an alternate juror gets called. I'm going to do anything to protect her anonymity. She just has to appear. Everybody sees who she is, knows who she is. I thought that was kind of funny. But yeah, that's the reason you didn't see the jurors, and they did it that way. They were being very careful with the jurors. They wanted to treat them very kindly. They got asked 5 questions by the judge. They, as we said earlier, they didn't really testify in the way you think of typically. There was no direct. There was no cross. It was really just the judge asking them questions. And I'll say this, they started off the hearing with a bang, because they started off with juror Z, who, as Alice said, they did this to hide their anonymity. But there was one juror who you really couldn't do that with, and it was the one juror who had written an affidavit indicating that Becky Hill might have done some stuff that was improper. And she was the first juror to speak. They bring her in, and this actually turned out to be unfortunate for a reason I'll get into in a second. They bring her in. You can't see her. Judge Toll is asking the questions of this person. And for the first time, she says that the comments made by Becky Hill influenced her verdict. Remember, we had an affidavit from her. And in the affidavit, she said, yes, Becky Hill made some comments that were inappropriate, but she doesn't say in the affidavit that those comments affected her verdict. In fact, in the affidavit, she says that she went into deliberations thinking that Murdaugh was not guilty and that she felt pressured by the rest of the jury to come to a conclusion that he was guilty. Some people would call that pressure. Some people would call that deliberations. So in her affidavit, it seemed like, yeah, Becky Hill said some things she shouldn't say, but under the standard that the judge had picked, that's not going to be enough. But then, in the interim, between when she filed that affidavit, the judge made that decision, and she appears in court, now when she's asked, did the comments that Miss Hill made influence your verdict? She said, yes.
And really interesting thing about that is I can probably promise you if she had said that previously when she was writing her affidavit, Poot and the defense team would have included that in the affidavit. I would be a little bit surprised, actually, if they didn't ask that question. But something happened in the interim where either someone talked to her about it or was like, that's not enough. That's not the standard. Maybe she listened to illegal briefs. I don't know. But clearly, if that had been something that she said before, it would be surprising for it not to be in the affidavit. But whatever the reason, that was kind of a Perry Mason moment, right? That was a bombshell because you needed that. We've said that before. You need that to be able to even get close to the prejudice standard. But this is why we also said it's not enough to simply state the statement. The judge followed up with Juror Z. It didn't just hang out there and say, okay, well, game over, everyone go home, especially because she was the first juror.
And there's a couple things about it. Number one, the reason you have a hearing, and you do this way, is because the judge is not only eliciting information like a robot, she's also evaluating credibility. And credibility can mean a lot of different things. People think, when you say someone's not credible or you say you don't believe them, that means they're lying. They're consciously lying. Poot sent her $1 million and now she's going to lie through her teeth. That is not, that can be it, right? You can have a witness who decides to lie for any number of reasons. You can also have a witness who has been poring over this in her mind for the last year, who obviously, I think, just had trouble. I think there's a lot of people like this. They just have trouble finding anybody guilty. Some of you guys out there listening, we love you guys. Y'all have trouble coming to the fact that there are people who do really bad things, that bad things don't just happen. There's actually an individual who does it. And you have a really difficult time saying, okay, fine, I think it was this person. It doesn't matter how much evidence we pile on you. You just have a hard time coming to that. And I get that. It's hard to say, not only did someone do this, that person did it. And I kind of wonder if she just had trouble with that and she felt bad about it and probably felt guilty about saying a man was guilty of killing his wife and child. And this is all my supposition, and felt bad about it. And you can kind of see that in the affidavit. The fact that she said she went in thinking he was innocent but was pressured by the jury. She comes to this conclusion. She leaves. She's then like, man, I was bullied into that. I was pressured to that. And from that point on, she's thinking through all this. And then Poot comes to her and Jim come to her and say, did this woman say anything she shouldn't have said? And she says, well, I feel like I remember saying this thing. And Poot and Jim say, well, she shouldn't have said that. That's improper. And then they have a press conference. And then all this stuff is happening. You can imagine when she's sitting in that chair today, trying to think back about whether or not in that moment the thing that was said to her by clerk influenced her decision. You can imagine why that is actually a really difficult question to answer. And she's struggling with that, even internally. And it's different. And back when she was asked to write an affidavit, she didn't say that. But now she's willing to say she did. And you and the judge have to decide, is this thing that I'm hearing from this person concrete enough that I'm going to overturn this verdict? And is it concrete enough to create the kind of prejudice that we talked about before that overcomes the weight of the evidence in the case?
Yeah, absolutely. And any one of you who's testified before, it is a whole brand new game when you're sitting under oath being questioned by a judge. And even though you're not being shown on camera, you know this is televised. And look, while the jurors were hearing evidence in the trial, they were not supposed to consume any media. We are post-trial, and they've had to be living under a rock not to see all of the media that has happened ever since the defense filed their affidavit alleging that there were jurors who had been potentially tampered with. So nobody's under like a no contact order, no nothing order. They've probably talked with a lot of people in the interim. We're talking months since that affidavit was filed. We know that there have been lots of televised news about this, and people know, because, you know, the affidavits are signed with real people's name, who these individuals are, who the defense based their allegations on. This is an immense amount of pressure to put on anybody. And it doesn't necessarily mean you lie on the stand, but it certainly means, we've talked about this, when someone's being interrogated, sometimes answers come out different than what is the truth because of the immense amount of stress and pressure someone may be under. This was a very stressful situation for Juror Z. It was stressful for all of the jurors, honestly, but I would say it was uniquely stressful for Juror Z because first one to testify, and because Juror Z had written and signed an affidavit, unlike a lot of the other jurors. And so their words were already out there, and there was something by which to look to previously to ask why certain answers have changed or something has been added at this point. So this was not the rote 4 questions that we saw with the rest of the jurors. Put yourself in that position. You may feel like the whole weight of whether this man gets a new trial is on you. One way or the other, someone is going to be massively disappointed. The prosecution or the defense and all the eyes of the nation, maybe the world, are on you. And you may think that your answers will be the deciding factor. I mean, I just want to kind of remove, I know a lot of the talking heads on TV were like, whoa, no trial, crazy, all these things. Or maybe some other people are saying, oh, Juror Z lied. Step away from that for a moment and let's humanize what Juror Z was going through today and why perhaps what came out of Juror Z's mouth at that moment in answering the question in the affirmative as to whether their decision was affected by what they heard Becky Hill say is that there was pressure. And that's why the judge wanted to be the one to ask that question, not one of the sides who stands to benefit from the answer, and why the judge also wanted to follow up to better understand this is a very important, very substantive answer that you're giving me. That is not something that appeared in a sworn affidavit filed closer in time to when this decision that you're saying was affected was made. So how much weight should I put into this answer now? And how much do you actually believe that right now?
And it's funny, there was more pressure on her than if she had just been a juror again, because it was all her. And she would have known that. The other 11 are going to say, most of them are going to say, she didn't say anything to me. And if she did, it didn't have any effect on my verdict. So you got 11 people, 11 of the 12 who are like, no. It was like, quick, bang, bang. No, didn't say anything. No effect on me. So she knew if he's going to get a new trial, it all comes down to her. I mean, the pressure on her was immense. And I think the judge tried to work through this with her by bringing in the affidavit. And it was funny because Harpootlian, initially, he wants to bring the affidavit in. And then the prosecution points out, yeah, and we're going to ask her about where she didn't mention any of this. She said the reason she came to her conclusion was based on deliberations. And Harpootlian, and this is like the best part of the thing, because Harpootlian was totally put in his place. He's like, oh, well, they can't ask that. And the judge is like, so you want me to admit this, question her about it, but not ask her about the most important part? And Harpootlian had really stepped in it. At one point, attempts to withdraw his request, which the court denies his motion to withdraw his request, and tells him to go sit down. And there's like, if someone hasn't done sad Poot meme, you need to do it. Because Poot, after she's like, sit down, the camera on him, he's like, sad old man. He just kind of turns around and shuffles over to his seat. And there's this lady who's, I think, on the prosecution team, sitting if you're viewing him to the left, looking, and she just looks totally stunned at this whole thing. It's great. The whole thing is amazing. Anyways, check that out.
I mean, I thought that was really interesting because we said going into this that Judge Toll has been around the block a few times. She's seen a lot, right? She has a lot of experience, and she was not, whatever happened in these hearings, she was not going to make a mockery of her courtroom. And by shutting down this kind of, you can't have your cake and eat it too request, she didn't humor it. You know, the defense had plenty of opportunity. This is 3 days of hearing. They got to file all sorts of things. They got to file pseudo affidavits. When I say pseudo affidavits, they say, you know, it's a lawyer's affidavit of someone else's testimony. Like, what is that? I don't know. They've gotten to get all their words out there, and she was not going to suffer fools today. And she made that very clear, actually, at the preliminary hearing. And you kind of have to do that right now, especially when this is already dragged on for long enough and real people's lives are affected. All these jurors who have been dragged into court to actually testify on the stand when all they did was answer a letter summoning them to become part of the jury veneer, you know, a year plus ago. They didn't ask to be on the jury. They were summoned and they did their duty. And now they're all being dragged into court one by one and questioned under oath. So she recognizes what all of this means and how serious it is, and that this is not the time for theatrics.
So at this point, she asks the juror about her affidavit and goes through the things she said in the affidavit and said, do you stand by what's in the affidavit? And she did. And then she said, so does the affidavit more accurately reflect your feelings on this? And she said, yes, which is a or I don't know if it's a contradiction or a clarification, or she changed her mind again.
It's like a cross-examination. Right.
And she said yes, and so they let her go. Well, Poot, of course, gets very upset about this question and says, you know, I feel like you're presaging how you're going to rule in this case, which it totally did. But nevertheless, I mean, that was the key question. When you gave the affidavit 6 months ago, was that a more accurate reflection of how you reached your verdict? Or is what you're saying now more accurate? Was it the jury deliberations that led you to convict? Or was it pressure from Becky Hill that led you to convict?
And here's the thing. It was not an unfair question. That is the question you have to ask, whoever you are. Whether it's, if this were just a witness who were being cross-examined by whatever side, if you had an affidavit by a witness that was, it's not exactly it is a contradiction. You are supposed to impeach that witness or confront them with a prior sworn statement that they had to explain why there's an inconsistency and which one is more true, being faced with both statements. And that's exactly what she did. That was an absolute fair question, and it was the necessary question to ask. And if this were any other type of hearing and she were just a witness and one of the attorneys were questioning her and cross-examining her, that is the next question you would ask no matter what. In fact, when that happened, I literally said, ask her about the affidavit. and that's exactly, I mean, every attorney who ever does any cross-examination would say, yeah, absolutely. Ask the next question. That is the next question. We've even covered this in jury voir dire before, when potential jurors answer certain questions like, you know, have you prejudged this case? And people are trying to get off the case will say yes. You don't stop there. You don't no longer like pick for the case. Or you say something like, are you a racist? And guys, people will say yes to that question to try to get off the jury. And they'll say, yep. And then that doesn't stop there. It's not like you raise your hand, you get to be off the veneer and not picked for the jury. Then there's a follow-up question typically done by the judge and to try and test if you really mean what you just said. So usually the follow-up question is like, can you put aside, you know, your prejudices or can you put aside your previous experiences and follow the law in this case? And almost 99% of the time, the person will kind of hang their head because they recognize that they've been caught trying to get off the jury. And they'll say, yes, I can. And that's called curing that particular juror.
And I know we're spending a lot of time on this, but this is the entire hearing, really. And we're going to talk about the rest of it. And there's some fun things that happen in the rest of the hearing. But this is the key. Either she voted to find Murdaugh guilty because of what Becky Hill told her, or she didn't. And all this stuff is hard. And this is one thing I think we always try to communicate, and I hope people get. The law is hard. It's always hard. It's never easy. Everybody wants easy. They want it to be simple and straightforward. If somebody confessed, they did it. If she answered yes to that question, we need a new trial. Like, that's not how it works. You always have to, somebody lies, they're a liar, and you can never trust them. That is just not reality. And it is really hard to dig into both people's motivations, what they really mean, how significant what they said was, are they being consistent? And you're making these massive decisions. I mean, the decision about whether or not to retry a 6-week case, a 6-week double murder case, rested on whether or not this woman's testimony was clear enough and significant enough to undermine the jury verdict. That's a huge thing. And you can understand why it was something people had to wrestle with.
And this is important because I do know a lot of people who said, I don't care. She said yes to the question. That's it. Doesn't matter what followed it. That's enough to get a new trial. Like we've said, this evidentiary hearing is not about technicalities. It's not about saying the right words so you get to win, you win your motion if you get someone to repeat the exact words. It's not a genie in a bottle. There's not special words that are said and then that you get your motion granted. This is like assessing the credibility of any witness is like any conversation you have with anyone throughout the day. All of us are constantly having communications with people that are not explicit, and also people are not saying things that they actually mean. Think about the last kind of heated argument or fight you had with someone you live with, whether they're a small person or a significant other. You've probably in the heat of moment been like, really? Do you really want me to just leave today? Like, yeah. Okay, no, that's not really what I mean. So what if we just took as word everything that everyone said in the heat of the moment? That's not how relationships work, and that's not how people communicate either. And that's why, like Brett said, this is not an exact science. It's not like she says yes, therefore equals new, the equation says equals new trial. There has to be exploration of the credibility of that statement. Otherwise, we could all coach our witnesses to be able to touch on certain words, and it doesn't matter what happens in cross-examination or what happens in any other thing, or they say something completely contradictory later or previously in another testimony. As long as they say magic words, abracadabra, you'll always win. That's not a just system either. So this may be difficult to kind of understand if you haven't practiced law, but this is why it's very important for the trial court to be able to see these witnesses and to assess their credibility and to ask those follow-up questions, because it isn't supposed to be magic words, get you whatever you want no matter when.
And what's wild about this is the other 11 jurors who now come in are basically going to say that none of this actually happened. We're going to have an alternate who comes in and essentially tells the best possible story for the defense, that Becky was just rounding everybody up and having group meetings and telling them you got to find Alec Murdaugh guilty. The other 11 come in. The next 4 say, well, before this happens, we had a moment of, I'm going to call it a moment of levity, even though I think for the judge, it was a moment of great frustration. Nobody took the jurors' cell phones. So they're all sitting back in the jury room watching court TV as this first person testifies.
Can we just pause for a second? Remember when we've had other discussions about other maybe high-profile cases and about how fraught court is and how even if you have all of the protections in place, there could be human error that maybe someone hadn't thought about before. And all these talking heads on TV were like, nay, prosecutors, you just hate media and you just don't understand anything about the protections we have in place. We have the best protections and nothing can go wrong ever. I mean, come on. This was not part of a media protocol. They just forgot to take away their cell phones. And probably people were watching them stream on their phones and no one decided to say anything because they all saw each other watching their phones.
The judge comes back in and she's like, there's really no good way to do this, so I'm just going to say it. And she lays out that the jurors all had their phones. At one point, she's like, I've got to cool down. I'm going to take a moment. The judge is great, by the way. If you missed it, it's worth watching. Just for her. But she says this.
Seriously, she suffered no fools for anybody.
And she's like, I'm going to ask all the jurors about it, see whether it had any effect on them or not. At one point, my favorite part of the hearing. So Poot, he asked for time to sort of think about what they wanted to put on the record about this cell phone situation. And the judge told him, and I quote, I'm not going to take all day on this, son. And the thing is, Poot's like an old dude,
the son,
right?
Man.
But Judge Toll, I think, is 80. And I don't know if she's older than him or not, but the son thing was just great. It was another one of those great moments in...
It was putting him in his place yet again.
Yes, it was amazing.
I mean, she was clearly frustrated because that was just a failure on a lot of parts. And the frustration was like, could have gone a lot of ways, but like this was on this hearing was finally almost over. It was like, what are we supposed to do?
Yeah. She was like, we're not stopping. We're going. We're not going to stop here. So anyways, they had their cell phones, whatever. She starts calling them in. She asks them all about the cell phone thing. Everybody says, no big deal. The next 4 jurors who came in said they didn't hear Becky Hill say anything inappropriate, and whatever she said, it didn't have any impact on their verdict. You then have a juror who comes in and says he remembered her saying something about watching Murdaugh's body language, but that had no impact on his verdict. And that is similar to some of the things that other people had said. So now that's 6 jurors. Of the next 6 jurors, I think there was one who she said something about paying attention, but it had no effect on his verdict. And the other one said there were no statements or comments that were inappropriate, and anything she did say had no impact on their verdict. So essentially you had, of the 12, you had 3, including the first one, who said that she said something that was inappropriate. And then of the 12, 11 of them said whatever she may have said, it had no impact on their verdict. And then you had the one who started off, who initially said yes, and then, as we've discussed ad nauseum, sort of waffled on that. So that was the situation you had with the jurors. And that was the end of the solely judge-led questioning. At that point, we're getting to witnesses. And the pre-trial hearing, or the pre-hearing hearing, the judge said, I'm going to talk to the jurors, and we're going to have one witness who's going to testify, and that's Becky Hill. And that's it. It didn't turn out to be that way, but she starts off testifying. She is called by the prosecution. This is the way they decided to do it, have them introduce her. And then there was the cross-examination. And it did not go well.
It did not. I mean, I think she was... So obviously the prosecution starting off Becky Hill is like a softball, right? Because she's been prepped by them. She's already signed an affidavit. The pretty direct questions, they're going to be like the questions that the judge asks the jurors, because there's only kind of certain facts. She has to address each of the allegations. There's not going to be back and forth. It's not telling really the story or explaining away why the allegations or what the previous jurors said are not true. So this is a softball start. And even with the softball start, I will say it was a little bit rough. So Becky Hill takes the stand, she gets sworn in, that whole thing, and Creighton starts off. And he pretty much goes through the affidavit that she's already signed, where it addresses each of the major allegations, right? Not each of the major, all of the allegations that have been charged against her. He's asking her if she told the jurors not to be fooled by Murdaugh. She answers them very clearly. I did not. Asked about watching him closely. She answers, I did not. She says that she didn't tell them to look at the movements when he was testifying, and that she never said that this wasn't going to take long. She didn't say anything about the defense case wasn't misleading. I mean, it's very direct question and answer. I did not say that. I did not say that. I did not say that. Without kind of any explanation behind it. The way it was supposed to be, because this is all the prosecution really had to show. Address each of those allegations. And anyways, we know that there's going to be a lot coming in the cross-examination. And of course, the judge can always ask questions in these situations, and we'll get there. Creighton also asks about the Moselle visit. That was part of the allegation of her going to the Moselle property and saying improper things to jurors there. Now, she commented simply that when she went to the property, she only said that it was beautiful. No other comments. So again, denying any of the allegations the defense put forward about what she said at Moselle. Then they ask about media interviews for jurors. And yet again, Becky Hill gives a little bit more color on it. She says, never told them that they would be asked for interviews. I only gave them advice that after the sentencing, there was going to be an interest in the press speaking to them in New York. But she says that she never pressured the jury about giving interviews or speaking with the media. So generally, as expected, she just denies everything on direct, just like she did in the affidavit that was filed by the prosecution in response to these allegations. But then Poot gets up and he gets to cross-examine her. And this is not great for Becky Hill, because Harpootlian has talked to people and he has a list of questions that are not going to make her look good. And he does not hold back. And I will say the judge does not hold him back either.
And it was interesting, Harpootlian. There's a couple things about it. Number one, he asks a bunch of questions that he doesn't follow up on. The judge Toll is going to follow up on. It's almost like, and they didn't do this, I'm not accusing anybody of this, but it's almost like they talked about this beforehand and he was sort of serving up the volleys and she was spiking the ball, because he would ask Becky Hill questions. He'd leave it hanging and then Judge Toll would come back and sort of like prove that what she said was incorrect. There's a couple things that are just interesting about the entirety of Harpootlian's Cross. Up until this point, Judge Toll has been very harsh on Poot. She's denied everything basically that he wants to do. She's told him to sit down, basically put him in his place. But when it comes to Becky Hill, she lets Poot do pretty much anything he wants to do. She overrules, I think, all of Creighton Waters' objections. And I think it was very evident that she had some real questions, regardless of what the jury was doing. She had some real questions about what Becky Hill was doing and exactly how much malfeasance she may have had. And I think, there's a couple ways you can think about this hearing. One question is, should Murdaugh get another trial? But there's another question out there, and that's, regardless of whether or not it meets the standard to give him another trial, should she face sanctions for what she did? Should she be punished for what she did? Those are two separate questions. Just because Murdaugh doesn't get a new trial doesn't mean she didn't do the wrong thing and maybe even break some laws. Those are two separate things. And I think Judge Toll really wanted to give Becky Hill as much rope as she wanted if she wanted to hang herself.
And that's a great point, Brett, on the second part, because if those of you who are watching in real time, you may have started thinking that despite the presaged, question asked to Jersey, all of a sudden the judge was clearly very interested in what Becky Hill had to say and wasn't buying what Becky Hill was selling. But what Brett said there is very important, because here we have a clerk of the court who has been elected, is supposed to be a public servant. This is the only time for now, this questioning is going to happen. And in some ways, she was going to get to the bottom of this no matter what, whether it had to do with, because these are very serious allegations thrown against someone, one way or the other. If those allegations are completely false, I know I would want my day in court to be able to dispel all of them and clear my name. So there is that aspect. But the other aspect is these are such serious allegations, and she continues to be clerk of the court, that their entire jurisdiction has come under massive scrutiny. And if what she has done bears out to be true, something needs to happen, right? I mean, Judge Toll she's been a jurist for a very long time in this jurisdiction, and she has worked her entire career to make sure that justice was served in this jurisdiction. And she was not going to stand by and watch someone who wanted to personally profit from other people's trials have any sort of stake in this town. That was the feeling we got. And really, there's no charges against Becky Hill. There's no other hearing that's going to happen. This is it, and it's televised. And that's why she doesn't hold back.
And Becky Hill, to her credit or not, she doesn't take the fifth. She answers all the questions. And I think there's a question of remedies. There's always remedies in the law. Once again, I don't want to spend all our time on this, but this is so important. What is your remedy? And I feel like people see an injustice and they think that, there can only be one remedy. So if Becky Hill did the wrong thing, then Alec Murdaugh must get a new trial. These are two separate questions. Alec Murdaugh, whether or not he gets a new trial, is going to be governed by the standard that governs new trials. Whether Becky, and if he doesn't get a new trial, it doesn't just mean that Becky Hill just goes free and she can do it again. She can be worse. No, it doesn't have to be that way. And I think and hope that South Carolina will continue to hold her accountable if they can prove that she did some of the things that it seems like she did. Okay, so we get to this point. Poot's talking, and he talks about the book. And he's like, you were sending the book to your co-author, and then you had comments about the trial and the process that weren't in the final draft, sort of indicating like you were thinking about this the whole time. And you spoke to multiple people about writing a book, didn't you? And she's basically like, I didn't really think about writing the book until after the trial was over. She's trying to present herself as being totally focused. And then after the trial was over, then all these people came to her and wanted to write a book. Whatever, that's ridiculous. I mean, that's a ridiculous statement on the face of it. It's just, she obviously was thinking about writing a book the whole time. And this is Becky lies about stupid things. I don't know if she's lying about all of it, but she lies about stupid things all the time that are easily provable false.
And it's fine. Honestly, it's fine. There's no law that says you can't think about writing a book. This all builds the story as to why it's kind of motive of why she would do the things that she does. But this is why we say, she loses all credibility because she lies about the small things, the big things, everything in between. And we'll talk about how we know she's lying because she's faced, it's impressive the amount of denial that she can have even in the face of transcript contradiction.
At one point she's like, we didn't make a whole lot of money, just $100,000. And I'm like, I wrote some books that sold pretty well, and I didn't make $100,000, so congratulations, Becky Hill. Now, she ended up, I think, losing it all because she plagiarized half of it, but we'll get to that in a second. So, anyways, Poot asks her, here's the thing for all you witnesses out there. If somebody asks you a question that you didn't really expect, it seems like it's out of nowhere, and the answer to it is yes, don't say no, because they probably know that you did it. So, Poot asks her, just sort of out of the blue, did you ever go to give a juror a ride? That is a very specific question. If the answer to that question is yes, you just need to say yes and explain why you did it. The answer should not be no, because he probably wasn't just sitting around writing up questions and being like, air. I'm going to ask her if she gave somebody a ride. So, of course, she says no, and he lets it hang. He just lets it go. Right? He's going to come back to that later. Interestingly, I guess her daughter had been on the venire, and Becky's like, yeah, I really didn't want her to be on the jury. And then Poot's like, well, didn't you tell us she'd make a great juror? And she's like, well, yeah, but you asked about it. Well, who cares? Like, did you want her to be on the venire, or are you telling the defense attorney she'd be a great juror? Well, it's just sort of incongruities.
Which is really, really bad because she had that conversation with the person who's questioning her. I mean, this is not smart lying, right? She's being faced with the direct conversation she had with Poot.
Yeah, I know. He asks her, when she formed her opinion that he was guilty, and she tries to act like she didn't have an opinion until after the verdict, which is absurd. Of course she had an opinion, and there's nothing wrong with having an opinion. Everyone in the courthouse has an opinion about the trials that are ongoing. Particularly the people in the courthouse, they form an opinion. There's nothing wrong with having an opinion. It's whether you share that with the jury when it becomes problematic. He asked her whether or not she thought the Murdaugh family was a criminal enterprise, which she wrote in the book. She didn't really want to answer that question. And she started talking about poetic license and sort of like, there were things in the book that she was just trying to make it more exciting. Now, Harpootlian, he starts to get into the plagiarism. He hammers on this fact that she had decided that Murdaugh was guilty before the verdict was given. He talks about that she put incorrect stuff in the book, and he tries to say she was lying. Now, obviously, she's right. I mean, she's writing a book. She's trying to make it sexy, so she's gonna have some artistic flourishes here and there. But she's trying to say, no, I would never do that. I would never do that. It doesn't work. She comes across as very clearly minimizing, we talk about this all the time, minimizing the negative things that she was doing during this trial.
And here's the thing. I mean, Poot goes after her, right? I mean, he needs to. Everything hangs on what Becky Hill says. And there are times where he gets really aggressive that probably it would call for a judge to kind of rein him in. Judge Toll doesn't. It's very clear that she is unhappy with the answers that Becky Hill is giving on the stand. Because remember, when you swear to tell the truth, the whole truth, and nothing but the truth, you have taken an oath in that courtroom. And when you lie under oath in that judge's courtroom, you are not only lying and potentially perjuring yourself, but that is an affront to the very judge who is sitting there with the authority to kind of have this sworn testimony. And she is not happy with the answers that she's giving. So Judge Toll lets Harpootlian ask her all these questions. And then she starts to ask some questions, which the judge can always ask any of your witnesses questions. When the judge starts asking you questions, and this is not in the case of like the jurors, which we knew all along she was going to be the only one asking questions. When a judge starts asking you questions, it's probably you should really listen to the questions because the judge is asking questions that they want answers to. And it may not always be that they don't think the attorneys are doing a good job. It's that they want to know something, and they're not going to wait for the attorneys to ask. And they're going to ask their own follow-up questions. And judges can do this. The judge is the king or queen of their courtroom. They can ask while an attorney's asking questions. This happens to me all the time in trial. And then they'll say, "You may continue, counsel." They can finish, once you rest or sit down, the judge can say, I have some questions for you, witness. Please sit back down. The judge can do whatever they want. They can ask questions anytime. And it is not infrequent during an evidentiary hearing that you'll hear a judge ask questions. I'm saying all this to say that Judge Toll didn't do something completely out of the blue. This is something that you can expect a judge to do, especially when you have a witness who may be saying very contradictory things under.
I'll just say, my worst experience in a trial was definitely when one of my witnesses said something really dumb. And we've always said, when the judge sort of sits up and all of a sudden starts listening, that's when you know you have a problem. So the witness said something really dumb, at which point the judge not only sits up, he starts asking questions of the witness. And he asked questions of this guy. It seemed like an eternity. I just wanted to bang my head against the lectern as the guy just continued to say worse and worse things. And eventually, like Alice said, the judge is like, "Okay, continue, counsel." And you're just like, what's the point? No more questions. I'm done.
No more questions. I passed the witness.
But Alice is right.
And here's why it matters, right? The judge is charged with assessing the credibility. And so that's why she asks questions. And let's say she asks very pointed and direct questions. And honestly, she's very effective. She is more effective, I think, than Harpootlian. She asks questions that she's given more rope. Let's just put it that way. And what
May
she
I never
says
be questioned by Judge Toll or Alice. That's my hope.
No, Judge Toll. She definitely, and the thing was, she was completely transparent with what she was doing. She was not trying to hide the ball. These were not gotcha questions whatsoever. She was a little bit indignant in asking her questions because she anticipated what Ms. Hill was going to say, which was going to probably be something that was not the truth. And whenever Ms. Hill said something that was not the truth in response, you could see Judge Toll getting angrier and angrier, and she wasn't going to stop. She was going to continue to ask these questions because you can lie about the same question over and over. Those are all separate lies, So she was letting her do it. And we'll get into what she asked. So one of the things that she touches upon that we haven't talked a lot about yet, which we actually said in a previous legal briefs is not what this whole hearing was going to hang on, is Egg Lady. Remember Egg Lady? She was a juror who was ultimately dismissed. We call her Egg Lady because when she was ultimately dismissed from the jury, she specifically asked before she could leave if she could go to the refrigerator and get her eggs. So she's been known in the media as Egg Lady. Judge Toll notes that in a hearing with Judge Newman, the judge who was the judge over the trial, that there is a part of the record, so a written transcript indicating that Becky Hill did ask the Egg Lady direct questions. This is in the transcript. And this is in multiple people have said this. It appears in multiple parts of transcripts in kind of these outside of the purview of the jury's conversations with the judge. And all Becky Hill had to say was, yeah, I asked her questions. The questions could have been anything. It could have been, do you like Taylor Swift? It could have been anything. But Becky Hill says, no, never asked her direct questions before. Never. And she says this in many, many different ways. And Judge Toll gets kind of pretty fed up because she confronts her with evidence after evidence that, in fact, it appears that you did directly question her. And Becky Hill kept saying, no, let me think about this. No, I believe it was a staff member of mine. And this is the demeanor in which she was answering questions, as if she were thinking back for the first time, not like she hadn't been thinking about this for the last 3 to 4 months since these allegations came out. No, I never asked her questions. No, certainly a staff member. No, that's absolutely what it was. And here's the thing. Whatever you think of Egg Lady, there may be, there have been allegations thrown about her, whether she should have been dismissed, not dismissed. There's no reason for Egg Lady to be lying about Becky Hill asking her questions about Facebook posts in particular. There's no reason. Someone asked her those questions, Why would she say Becky Hill if it were somebody else? It doesn't get her anything. It doesn't mean that she's all of a sudden, the ruling's overturned and now she's on the jury and now there's a new trial because a juror had been removed. No, this has nothing to do with Egg Lady. And I'll let you jump in on this.
And the key here, this wasn't about Egg Lady. As Judge Told already said, I don't care about Egg Lady and why she got removed. Doesn't really matter. She didn't decide this case. It's about her credibility. And it's like, we talk about this sometimes. People who lie about the worst things. Because you're lying about something that doesn't actually affect whatever it is that's going on. But your credibility is going downhill. So all Judge Toll wants her to do is admit that, yeah, you asked some questions to Egg Lady. Maybe you shouldn't have done that, but you did. And she refuses to do it. And it's just like, there's no reason Egg Lady would say you asked this question. None. It doesn't even make sense that Egg Lady would lie about that. Why are you lying about it?
And there's a world I can imagine how this hearing would have gone where Judge Toll didn't ask these questions. Because like you said, it doesn't have bearing on her ultimate decision of whether a new trial is necessary because Egg Lady was dismissed from the jury. So she was not one of the 12 to vote to convict Murdaugh. But I think at this point, she was so fed up with these very obviously contrary to the evidence answers that Becky Hill was saying that she was like, all right, let's get into this because I have receipts here and they're not adding up. And she couldn't get a straight answer from Becky Hill. And that was very frustrating for all of us watching. I was sweating bullets for Becky Hill. I was like, please just say yes. Like, it's okay. Just tell the truth. And that was it was a tough questioning to see only because everyone else watching could very clearly tell that this was not a truthful answer. So she didn't stay on there. She didn't stay with Egg Lady because, again, Egg Lady kind of doesn't matter here. But she does talk about yet another thing that would have very serious ramifications if true. Talked about the sealed exhibits. And Judge Toll says it's the duty of the clerk of the court to handle the sealed exhibits. Sealed meaning sealed from the public. But we know that there are photographs of the victims' bodies at Moselle that were supposed to be sealed, but they got out into the public. And Judge Toll asked Becky Hill about how these sealed exhibits got out to the public. Now, Hill immediately distances herself, doesn't say anything about maybe I did something, maybe I put it out there. She immediately gives an excuse. And she says, oh, I know what happened. Someone was in the gallery of the courtroom and they took pictures of the screen. And Judge Toll asks her very directly now. She says, have you ever allowed the press to view any of the sealed exhibits? Becky Hill says, no. Judge Toll comes back with another very direct question. Have you ever allowed Netflix to examine the sealed exhibits? I mean, these are very pointed questions because these are people who've received the sealed exhibits, and she is the keeper of sealed exhibits. And again, Becky Hill responds, no. I mean, this is very, very big because we've talked a lot in the Delphi case, how important it is when something is sealed by the court, that it is a court order, and that sealed evidence, whatever it is, should never get out in violation of the court order. Here we have the keeper, a court employee, who is the keeper of the court-ordered sealed exhibits, having to answer very direct questions about the public receiving access to these sealed exhibits. And this is very frustrating because there is more back and forth here, and you can tell that there's massive minimization by Becky Hill. The judge says, really? Because I think in your book and previously you've said many times how late you had to stay every single night to make sure that you dealt with the press and the exhibits and all these things. And she immediately says, no. Oh, I barely ever handled the exhibits or the press. I didn't never stay late. Nah, I just went home. My staff handled it. It was always her staff that handled it. I don't know how big her staff is.
She throws them under the bus.
I know how courts work. Clerk, yeah, no kidding. Clerk of courts probably don't have huge staff, and whatever staff they have, she is definitely throwing them under the bus with Egg Lady direct questioning, and also with these sealed exhibits that, if they got out to the media, is in violation of the court order.
Yeah, and then she says, "Oh no, I never sent anything to anybody," and then she's like, "Well, okay, I guess there were some exhibits that got out to Netflix, but that was an accident. That was a mistake. We mislabeled those, but that's it. No other sealed exhibits ever got out anywhere. And then Harpootlian gets up after she's off the stand and is like, well, I have a letter, or I have an email from, and then he attempts to pronounce a Japanese person's name, fails miserably, refers to him then by his first name because he can't pronounce it, and says, and it's an email between Becky Hill and this producer of, I guess, a Japanese documentary about how they had accidentally sent body cam photos or body cam footage, which, by the way, of course, has the bodies in it, and they need them back. And it's like, oops, I guess you missed that. And Judge Toll points out that this is, and starts to admit things. And she starts to admit things into the record because clearly Becky, there are some things that contradict what she said. And so Judge Toll went from, we're just hearing from Becky Hill, we're not doing anything else. She's admitting stuff into the record. And then when Poot asked to be able to call some people to contradict what Becky Hill has said and to call her credibility into question, Judge Toll's like, yep, I think we got to do it. And so one of the best witnesses of the day, who I can tell how she gets elected, is Rhonda McAlveen, or McAlvin, or Alveen. I don't know exactly how to pronounce her name. But she comes in. She is actually the clerk of another county in South Carolina I tried to catch. It's like Arlen County. But, I mean...
the accents were thick. I honestly couldn't get it.
Me talking about somebody's accent is a little out there, but these accents are just... they are just crazy, guys. I mean, they are so crazy.
You talk about... Okay, we are really excited about Rhonda. I know we're running long, but nobody cares. Rhonda, awesome. So she's the clerk of... what did we decide it was? Harlan County? Arlen.
No, somebody said what it was. It's like... What is it? You guys can do it. Give it to me. No, they mentioned it earlier, but now it's way up the chat, so I'm hoping somebody will just say it again.
Okay.
Okay, so Rhonda, she is a fellow clerk. And Becky, she's a clerk from Barnwell County, which sounded like Arnold when she said it. But she's had a lot of experience in murder cases. She's been on a lot of murder cases. Becky had not. She'd never done a murder case before, so she was hoping that somebody would help her. And she called in Rhonda because they're good friends, or at least they were before today. Because I'll tell you, Rhonda's testimony was about as impeaching a testimony as you could possibly imagine. Everything Rhonda said contradicted everything that Becky said.
Remember those questions that we talked about where they came out of nowhere for Poot and he just let him hang? He let him hang because Rhonda was coming in to do cleanup.
Rhonda comes in and says Becky was talking about writing a book in December before the trial even started. And then she was telling her she really hoped for a guilty verdict because that would sell way more books. She also testified that she found out that Becky had driven a juror home and had confronted her about it and said, you can't do that. That's a violation. You're going to be accused of all sorts of improprieties. And Becky's response was, well, the bailiff was with me. I was kind of interested the bailiff didn't testify because he actually would have been able to speak to some of this, but he didn't testify. And she said that Becky told her some of the same things that the few jurors who claimed that Becky had spoken to them said. Things like, watch Murdaugh really closely. Don't be fooled by him. Watch out for what the defense is going to say. Now, one thing that she would say, and I don't know how actually helpful this was, but she would say she never heard Becky say this in front of any of the jurors, but that doesn't mean that Becky didn't repeat what she said to her.
I mean, and it's interesting because clearly she's saying this to Rhonda, which means that they're the same words that we've heard other jurors say, and Rhonda wasn't in front of the other jurors. So there's some believability that these are her choice of words and her beliefs and her impressions on the testimony, and that if we're hearing kind of the same words attributed to her by different people in different situations who are not all in the same room, it begins to lend some credibility to everyone's testimony.
Now, Rhonda was hilarious. She had people rolling in the aisles. You just watch Rhonda's if you don't watch anything else. Now, Rhonda did say that she had never seen and she had never had anyone tell her of any conversations or any things that Becky supposedly said to the jurors that were inappropriate. So that was a little bit of a salvation, but when it came to Becky and her credibility, I felt like Rhonda pretty much destroyed it. Rhonda wasn't on the stand for long, and then juror 741, who was an alternate, was called in. And she basically said that all the stuff, all the worst possible things that you had heard, Becky Hill had said. Not to let Murdaugh confuse them, that the defense was going to lie to them, that they should show their emotions on their face because that's what they want to see, which I assume is the press. And the one thing about 741 that I'll say, she was almost too on the nose. It was as if the defense could have written out the script of exactly what they wanted her to say, she said it, to the extent of having like all the jurors gathered together with some of them in the hall and some of them in both rooms, telling them all these terrible things and that were prejudicial to Murdaugh. I mean, she said it all, and it's just impossible. It's impossible for her and for the other 11 jurors to be telling the truth, because there's no way that those 11 jurors could have been in the situation that she described and not heard the things that she was saying happen. So she was an interesting witness because of that. And it was something that Judge Toll obviously had to take into account in deciding how to rule on the case.
By the way, this happens all the time. Right? Like when you have witnesses and you have to weigh what they say against each other. But here we have one juror who's an alternate versus 11 12, other jurors who've testified to something different. And this is what we mean by weighing the different testimonies. This is what you do when you're on the jury, is you're going to hear lots of witness testimony, and they're not all going to be, perfectly in line with each other for a number of reasons. It may be as simple as misremembering things. But in this case, it does seem like it's kind of scripted out and saying all the right things, except we've said this before, because she's an alternate, she did not vote to convict. It doesn't factor into whether it affected the jury verdict. Now, we've reached the end of the hearing multiple days, and the judge did not waste any time. Maybe she took a recess. I can't remember because I fast forwarded through a lot of things. I mean, it was like I skipped ahead too quickly, basically, when I was watching it, because the recess she took was so short. Now, a lot of you have been wondering, well, if she ruled so quickly, did she already write something out? Here's the thing. You can watch what her ruling is, and she gives an explanation as to what she is ruling upon. Brett and I have both worked for multiple judges. Oftentimes you will see judges do this, especially when they've studied the record, studied the briefs. They know all of the record going into the case. They can speak very fluently about their decision, and they may have an inkling of how they're leaning. Perfectly fine. They've read all of the law. They've read all of the facts as presented to them. And then what they have to do at the hearing is to weigh the credibility of the witnesses and what they have to say. I don't think she was reading from a script. I think that she had an idea where this was going, took the time to kind of gather her thoughts before she made the ruling, which was a speaking ruling. In other words, she didn't just say, granted, denied. She gave an explanation of what she was ruling upon.
Yeah, and I think this is really important because I feel like people expect that it's required that judges have to go back into a room somewhere and, sit like the thinker and ponder over everything they've heard, decide what they're going to rule on. When in reality, they have studied a lot of stuff before they ever walk into the court. You can change their minds. I'll give you an example of that. When I was clerking, the way clerking works is you get these cases, you work up a bench memo for your judge. Basically, you go in and say, this was when I was clerking on the appeals court. You basically go in and say, hey, looked at the case, here's all the things. The judge will call you in and ask you a bunch of questions. So to get him set up for oral argument, giving questions to ask and all this other stuff. And so in this case, we had sort of reached a conclusion. We were going to come out a certain way. Now, we're still going to have oral argument. And the way we were going to come out, by the way, was absolutely right. We go to oral argument, and the lawyer for the other side was fantastic. And the lawyer for the side who should have won was terrible. And they go back into conference, and the judge comes out, and he's like, yeah, we've decided to go the other way. And I'm like, that's not the right way. But the lawyer had been so good that they had changed things. That is rare. Usually, you're not going to see that kind of change. So what Judge Toll, I think when she walked in, given the standard, given the record, it was going to take a lot to push her.
Given the briefs.
Exactly.
Remember the briefs.
It was going to take a lot.
Like, the thing is, we all watch, like, whether there's trials or hearings, and we just see the fun part that TV is made that makes lawyers look like, right? You think that all lawyers do is, like, walk into court and, like, swagger into court and get to, like, wax and wane poetic left and right. That is, like, a very tiny part of what you do as a lawyer. The majority, if you're going to have a hearing, there's going to be briefing on a case, meaning that is really usually what the judges go back to in order to write their opinion, if there's going to be an opinion, because that's where the citations are. That's where, the pin sites are to the specific language within certain cases, and how you draw the analogies and the reasoning is all on the papers. That's why usually at the end of an oral argument, you'll hear an attorney say, like, I rest on my papers. That's what they're talking about. They're briefs. There's briefs that the judges get to go back and pour over, that they, if they're a prepared judge, have read and know well before they even go into the hearing. So just so you know, the judge has been, like, thinking about this, and we begin to hear, how much preparation she's done this. She says that she has read the entire trial transcript, which is no easy task. We know, we covered this trial because it was a very lengthy trial, and you write it all out on paper, and having to read it, that's pretty dry, and it's also very long. Okay, let's get to what she ruled, because she cut to the chase. There is no new trial for Murdaugh, because she also, so that's number one. And you can see how she reaches that decision, because the only one that may have gone the other way was Juror Z. But because of that follow-up question she asked, she is allowed to kind of weigh that credibility, and the whole way that the evidence goes to no new trial for Murdaugh. She also makes the ruling that Becky Hill was not credible, and she does not hold back Judge Toll. She says that Becky Hill wanted fame and a book, and probably did say things that she shouldn't have. I actually found this important because Judge Toll acknowledges that Becky Hill did wrong things, but that, and this is important for appeal purposes, that doesn't change the fact that it did not affect the fairness of the trial that Murdaugh was given. And she even says something like she gave the siren call of celebrity. I mean, whether she wrote it out beforehand or not, I mean, it was quite the speech. It was like Count of a Few Good Men or something. And Judge Toll also determined that this, despite all of the bad things that she thought Becky Hill did, this was not sufficiently prejudicial to overturn the verdict. And she makes a point of going over the strength of the government's case, the prosecution's case, and having had read through the entire transcript of the trial, and noting the weight of the evidence was overwhelming against Murdaugh. Now, she goes this extra step, partly to appeal-proof her decision, because this will be appealed, certainly. But also, I thought it was like a nice nod to Judge Newman, who, recused himself from this particular hearing, of doing a good job of overseeing a very long, lengthy trial, and recognizing for everyone who's watching that the evidence is, in fact, overwhelming against Murdaugh.
And I think what you saw here was the opposite of what you saw in Delphi. Judge Toll probably, if she'd wanted to, could have ruled on the briefs and said, look, you're not going to meet the standard. You lose. Get out of here. I'm not wasting a day of my life to do this, right? But she didn't do that. She had the hearing, and then she gave a ruling, and she was thorough in that. She not only talked about what she heard that day, but she talked about the weight of the evidence, and all of that. The thicker the record that you send up on appeal, the more likely you are to be affirmed, because the appellate court has to look at everything the court says. And they're going to have to look at not only her decisions about the credibility there, but also the way she weighed the evidence in this case. The evidence at trial and the evidence of possible prejudice. She did all that. And it's a much bigger hill for a appellate court to climb when they have this very thorough finding by a judge on the record, laying out why they did exactly what they did, than what you had in Delphi, where basically you could construct it through the various things that happened, why the judge did what they did, but the judge didn't do all the steps they should have done to appeal proof their ruling. Her ruling is going to be very solid. Now, what's interesting, in a way, she did the defense a solid, because she made a factual finding that Becky Hill is not credible and that she made these statements. If the defense wins on the law, if they can get the courts in South Carolina to say that when a member of the court staff says something inappropriate to the jury, that is sort of structural error, automatic retrial, no need for prejudice, If they can convince the court of that, then the judge's factual finding supports that, because she made the factual finding that she did make those improper statements. So this was a very even-handed decision. It is an absolutely correct decision based on the legal standard that she laid out. And the real question for the courts is going to be, is that the correct legal standard or not? I think it is, but it's for the South Carolina courts to decide in their state what standard they are going to apply to these kind of interactions with court staff.
It was a very strong showing by Judge Toll today. I thought she handled her courtroom very well. I agree. I think this was the exact right decision based on the papers, the briefs, as well as what we heard in court today. So hopefully this demystifies a very long day of hearings, although a lot of it was waiting around for things to happen. But if you have any questions, we've been reading the chat on the side. You guys have brought up some very good questions. But if you have any other questions about what's going to happen from here, I think the defense is going to appeal, and I think it will be denied, and that the judge's ruling will stand here. But I think what this means is there will be no new trial for Murdaugh, and I think that is absolutely correct. Is there anything else you'd like to add, Brett?
Questions. I know that we've been going long, but I do want to.
Yes, we can.
We'll do questions.
I'm feeling
I will
enough.
Say
I
one
can
thing.
mute every time I cough.
Delphi is Vietnam. Delphi is a quagmire. Delphi is World War I on the front. Delphi is the Somme. It is this just intractable problem that's never going to go away. And today we got artillery fire from both sides. The defense filed a motion to recuse the judge, which is not unexpected. But what was unexpected was the prosecution filed a motion to basically find the defense attorneys in contempt, which they should be. But what was really interesting is they went into some detail about the leaks that went beyond just the photographs. We've always heard, they broke into their room and they took pictures they shouldn't have taken. Well, the prosecution clearly has some evidence, it sounds like, that the leaks have been going on for longer than that. Yeah, the leaks have been going on longer than that. The defense team leaked, I would call it a leak. They shared the Franks motion with the same person, by the way, apparently, who took the photos and leaked them. The Franks motion included discovery that was under the protective order that should not have been shared with just some random person. All the exhibits should have been sealed, which the defense even admitted in their discussion with the judge. They were just like, we thought you would do that. We didn't realize we had to do that because they've never practiced law before. And it seems like there are pictures of various conversations between various people that involve information that they could only have if the defense shared with them. So
can I just note, oh my God. I mean, we're not, okay. This is a whole nother legal briefs, but we have said time and time again that all these things keep coming to light that are really negative for Rosie and Baldwin because they keep requesting that they be brought up, whether it's in their own filings or they really forced the prosecution's hand in this instance. I'm sorry, I'd be bowing out and be like, I'm going to continue to practice and you guys never speak my name in the media again. But no one asks for it. But in a way, they did ask for this specific thing because this was part of their request for a mandamus, was they wanted this hearing. And the prosecution's like, yeah, here are all the witnesses that we were going to put on at that hearing. Remember that you wanted. And if nothing's in the record, let's make it part of the record. Let's have this contempt. And they want a hearing. And there might be a hearing.
Look, I think what's going to happen, I mean, who knows what's going to happen. But if I were vindictive Judge Cole, which, I probably would have recused by now because there's no way I could deal with these people and not be biased against them. I would deny their motion that I recuse, would be the first thing I would do. And the second thing I would do is I would set a 5-day hearing and I would have the prosecution come in and put on every piece of evidence they have about everything these two have ever done that's improper. And then I would remove them again. That's what I would do.
It's really interesting because we don't have an opinion from the Supreme Court yet, but we've talked about how I don't know that I'd have the hearing. It looks vindictive, all these things. So the prosecution did the work for them. It's a filing. Yeah. They're asking the court to do something. So the court doesn't have to set a hearing on their own. Remember, the removal was on the court's own motion. Now the prosecution's like, fine, We'll do it. And they have to deal with the motion. It's a pending motion. The other side has to respond, and there has to be a ruling on the motion.
And that was even one of the complaints by the defense, that even the prosecution didn't move for us to be held in contempt. Well, they have now.
That's why I'm saying they literally asked for it. I'm not saying that in like a derogatory sense of like victim blaming. Literally, they asked for it, and the prosecution delivered. That's what they asked for, and they delivered with a very hefty motion. Y'all should go read it. But again, another.
And I'll just say, and I've always believed this, if they have an evidentiary hearing, it is going to be really, really bad for the defense. It's going to look really, really bad because I think a lot of stuff's going to come out, and we'll see. I mean, I don't know, guys. It's a mess. It's just a mess. And it's a testimony to, and we talked about this before. Number one, prosecutors and defense attorneys need to work together because it's not about us and it's not about the defense attorneys. It's about the defendants and the victims, and it's about getting justice for both. And it doesn't have to be like it is in Delphi. And I'm not blaming the prosecution. Call me biased if you want to. I don't think it's the prosecution that's caused all the problems in the Delphi case. I think it's mostly the defense and these defense attorneys. I think when prosecutors and defense attorneys work together, they can move forward to a resolution for both parties. Richard Allen doesn't want to sit in prison any longer. He doesn't want to sit in the county jail if he gets moved to county jail any longer. He wants to have a trial. He wants to have his rights vindicated. The way to move towards that is for everyone to work together. That's not happening in the Delphi case, and that's one of the reasons it's stuck in a rut. The other reason it's stuck in a rut is because the judge, unfortunately, I think, has failed to recognize just how bad things have gotten. It's like when you watch a football game, and the referees are allowing it to get chippier and chippier, and players are getting more and more sort of in each other's faces, and then all of a sudden there's a big fight. Well, part of the reason there's a big fight is because the referees didn't take control of the game. And I feel like Judge Gold has failed to take control of this case in a way that she should have. And that's why we're where we are. If this had happened 3 months ago, if she'd have said to the prosecution, look, you want these guys removed, file something. And they'd filed this, and then she'd set a hearing and a briefing schedule. It would have been much more like what you're seeing in Murdaugh, where, you know, Judge Toll, if she was in charge of this case, Baldwin and Rossi would be practicing law in like an Alaskan border town right now. Like they wouldn't be in Indiana because she would have gotten rid of them. But that's not what happened. So I don't know what's going to happen. It's the worst possible thing for, I mean, I joke about
this is terrible as attorneys
again, but this is terrible.
This is terrible for the attorneys
case.
As attorneys who have careers, right? I mean, this is all terrible. But anyways, you wanted to do questions?
Oh, yeah, we want to do questions. So that's what's happening in Delphi. We'll follow up as it develops. I promise you, Legal Briefs is not intended to, nor will it be, the Murdaugh, Delphi Idaho show. Yeah, but that's what it seems like
but
it's turned
we
into.
may have knocked out one of the trio today.
That's right. Murdaugh, gone. Until the South Carolina Supreme Court in 2.5 years rules that the wrong standard was applied and we're doing this trial over again. Murdaugh is done. Okay, here we go. And here we have Legal Briefs questions. Let's see. Okay, this is from Jason. Where were you and what were you doing when Milroe hit Bond in the corner of the end zone on 4th and forever? For those of you who don't know, this refers to the Alabama-Auburn game, the Iron Bowl from this year, where Auburn was winning by some miracle. At the end of the game, it was 4th and 31. And in a miracle play, Alabama's quarterback threw a pass in the corner of the end zone that was caught by a wide receiver who now plays for Texas, ironically, for a touchdown. Where was I? I was standing up in my living room, prepared to be incredibly sad and just utterly stunned by what happened. I just remember my brother-in-law was there with me, and I just remember like hugging him and being like, he got it. And so that's where I was. Where were you, Alice?
I was also watching and celebrating a little too early, apparently. And then, because those of you who don't know, I don't cheer for Bama. And I think I was just about to smack talk. We were smack talking a couple Bama fans, and then it came back in full force. So we had it coming to us. Let's just put it that way. Some of them may, be judges, and some of them may have had a really good time sticking it in our face.
Yeah. Okay, here we go. I'll ask you a non-football question. But, I mean, these are the questions people ask. What am I to do other than
you got to answer them,
Okay. I don't know about this question, but I'm going to ask it of you anyway. This is from Soz. My question is, did you ever take a class in law school or otherwise that made you cry, figuratively, as in you were pulling your hair out because it was either hard or boring or brilliant, etc.? And how did you persevere?
All of them? I did not love law school.
Oh, I didn't either. I did not.
I think the fact that I did like an eight show a week run with Yale Repertory Theater tells you how much I enjoyed law school. Okay, let me try to give a real answer to that, because that could be that it was bad or good, right?
Yeah, I'll give an answer and I'll let you decide. So the class that had the biggest effect on me was either my what was it called? It was like culture and food class, where I learned how to cook.
And this is a law class?
No, this was in this was in college.
Wait, I thought the question was
about law school. Did it have to be law school? I thought it was any class.
Did the question say law?
It says in law school or otherwise.
Oh, I was like, because you know what? Can I just tell you that class totally exists at Yale Law School.
Does it really? That's beautiful.
Of course.
That's beautiful. So in college, I had this one professor. I took Eastern art history from her. I can't remember the exact name of it. Asian art history or whatever. And I loved it. It was like the greatest class. Of all the classes I took in college, the one I remember the most about is the art history class I took about Asia and learning about China and Japan and India and all the great sites, Harappa and Mohenjo-Daro and the Eastern Zhou Empire, like all of that stuff. I loved that. I loved it so much. And it inspired me to travel to Asia. So one of the reasons I went to Asia and spent so much time in Asia was because of that class. That was a great class. And then later on, she taught a food and culture class, which is where I learned to cook risotto, which is still my favorite dish. It's a great one. The ladies love it. The first time I ever had balsamic vinegar
that you need to impress.
Vinegar. I impressed her a lot with my risotto. I'm just saying. I mean, just great classes. So those are inspiring. Those are my inspiring classes that I took. My worst class? I took a class, the worst grade I ever got in my entire life, and this is going to sound bad when I initially say it, was in a class I took in law school called rationality. Which you would think would make me irrational.
But I was going to say, it's almost like taking a class on like the reasonable standard.
Yeah. So rationality. And it was the weirdest class because it was a Harvard law class, but it was taught at Harvard College, which I kind of want to do because I want to take a class at Harvard College. It was taught by a Harvard College professor who'd won the Nobel Prize, whatever. Great for him. But his whole theory of rationality was that, number one, God doesn't exist. There are three main theories of rationality. All three main theories of rationality lead to the inevitable conclusion that God did not exist. So I was like, and the entire grade was based on one essay that you wrote. And so I was like, well, I'm going to write how all three theories of rationality inevitably show that God does exist. And so that was my essay that I wrote for this professor. I did not fail, but I basically got the lowest. You can't fail. You can't fail at Harvard. I got the lowest possible grade you could get, and I have never been prouder of a grade than I was in that class. So,
That would surprise me, though, that, like, you're the only one who's ever done that.
I don't know that I was the only one, but
I would imagine that professor receives lots of papers like that. If anything, just because that's what Harvard does, is like to give a middle finger to the professor that the final project, the final paper is exactly contrary to everything the class is supposed to teach you.
Yeah, well, he didn't like that approach. And I'd always, in college, I did that a lot too. Like I had a professor in college who was like an arch communist. He was a huge communist. And he was my professor for history of the British Empire. And I'm like the most opposite anti-communist person you could ever be. And it was just like, we just fought all the time. But man, I loved him and he loved me. Like we would hang out after class. Like he liked that. He liked the intellectual sort of debate and the back and forth. And I totally respected him.
By the way, real intellects do.
Exactly.
Right? Real intellects like debate because they're not afraid of their ideas and they are also not afraid of their reasoning.
Yeah. So whatever. Screw that. That dude didn't matter. That class didn't matter. But I was glad that I did what I did. So that's going to be my crappy class answer. Okay, Alex, it's all you.
Man, I miss undergrad. I went to a liberal arts class. What? The fever is going great for those of you who asked at the beginning. Everything is fantastic. I loved going to liberal arts school because I took so many like geology classes, religion classes, and instead of just taking the classes, I would decide to like major in it, but not finish the major. So I was like a couple credits shy of being a geology major, a religion major, and a philosophy major. None of those were my majors, by the way, which just shows you how great liberal arts educations are. But those were so great because all I did was like sit around and look at rocks and go like spelunking and read, the great works of philosophy, which who has time to do that anymore? I really do miss that. But since you did college, I'll do law school. So I really did not love law school at all. I spent a lot of time dancing. I was in a dance company when we performed. We like rehearsed 7 days a week and performed like all over all the time. I spent most of my time doing that. I did a Shakespeare play at Yale Repertory Theater for like 8 shows a week for like, I don't know, it was like a 5-week run. That was like my 2L year, your most intense time of law school. And I did RA a lot of classes though. That's how I paid for a lot of law school, was I was a research assistant for a lot of professors. But my classes were always the best if it was the professor I liked. Like it didn't matter what the subject was. So my favorite professor worked in like international arbitration and conflict of laws. And she taught a class called Conflict of Laws, which we had like a cult following because we loved her so much. We would just hang out at her house uninvited all the time. Like she'd be like, do you guys have somewhere to go? Please go home. Not kidding. To this day, when we go visit, we go to her house and uninvited, and she does not live close to campus, which is why she's so awesome. She doesn't have the stench of Yale on her. But we decided to rebrand the class Conflict of Balls just because it was funny. And we got it all on our transcript as Conflict of Balls. So I have an A except there's no A. It was, what is it? What are our grades?
Pass?
We didn't have grades.
Do you have a high pass?
High honors, H. I was like, we don't have
yes,
A. H, yes. But there was like an H with an asterisk for my Conflict of Balls class, which means nothing because Conflict of Balls is not a thing, but Conflict of Laws is a thing. But this is why, by the way, my transcript probably means nothing to anyone, because it has no grades, but also we would get the registrar to change names of our classes because it made us giggle, and we would send it out to employers and no one would like actually check the classes and point out. The day someone looks at my transcript and says like, tell me about this Conflict of Balls class, I'm going to be like, I will work for you forever.
There's this myth out there that anyone should be impressed by the fact that Alice and I went to Harvard and Yale.
Nothing.
No.
Nothing.
No. What are you talking about? A fraud, an absolute fraud. The Ivy League is a fraud.
It is a fraud. It is a fraud.
F.
I will say this much. I will truly say this because I do know a lot of people listen to us who aspire to go to law school or have family members who are going to law school and who are going to take out a lot of debt to go to law school. I did not learn the law at Yale. I now know the law because of sweat, blood, and tears working for some really incredible mentors who did not go to Yale, by the way, who went to schools that taught you the law. I had a lot of fun in law school, dancing and doing plays and seeing a world that was like so foreign to me. I will tell you, as an immigrant child going to Yale, can I just tell you like my impressions of the first 6 weeks of school? All I could think was like, I got to start carrying Tupperware in my bag because they just have free food everywhere. Like, I was like, where is all this money coming from? Is this what my tuition pays for? Just free food everywhere? I never had to pay for meals because all the money went towards like free food. And so I would just like take food home with me because I was poor and had no money and couldn't afford food. And I would take free lunches.
I walked around the first year, really. I mean, maybe longer than that. I walked around Harvard like I was just like, I can't. Harvard is supposed to be like Hogwarts, and that's basically how I viewed it when I got there. I was like, this is just so incredible. I can't believe I'm here. And I wish it lived up to that. I really do. It should live up to that.
We'll say the best thing that came out of Yale, and it's truly were my friends.
The people.
But the thing about that was not because, Yale attracts great people. No, it was because my little group of friends, we all had massive trauma together for being thrown into this situation where like most of our classmates were like, no matter what they did in school, they could never show up to class. A lot of people never showed up to class and did not live in Connecticut when they attended Yale, and they still got a diploma where I went to every single class and have the same diploma because they have a building named after their dad, and they were going to do fine no matter what. And it was a world I'd never seen, and it felt so unfair. And so my little group of friends, we bonded together because we all came from nothing and we didn't understand this crazy world that was around us. And we like held each other's hands as we tried to figure out, as people said, what an interesting existential question you have. And I'm like, what does existential mean?
Look, and the thing is, the credential is just unbelievable. Like, the way people look at graduating from Harvard or Yale is like you walked on the moon or something. And I appreciate that. I have a lot of inner turmoil about Harvard and Yale because, I mean, I don't have a lot of turmoil about Yale. It's terrible. But Harvard, I have a lot of turmoil about Harvard because I felt just so incredibly blessed to have the opportunity to be a part of it. And I appreciated all the doors that it opened. Just having it, just having the diploma that said Harvard on the top of it was an incredible, it was just incredible. But the fact of the matter is, the smartest people I've known, the people I've learned the most from, the people that I've tried to emulate, none of them graduated from Harvard. None of them. None of my mentors went to Harvard. Like, it's just, like I said, there's what I want it to be, and there's in my mind when I went there what it was, and there's what it is. And it falls so far short of what it should be, particularly given how much it gets out of being, Harvard or whatever. So I don't want to seem like I'm not appreciative of it, because I am. And the fact that they let me in, which they did. I mean, they could let anybody in besides me, right? I mean, it's not like I was that brilliant. They just, for whatever reason, they reached down and decided I was going to be the person from Alabama that went to Harvard that year. Because that's what it was. I mean, that's seriously what it was. I don't know. I could talk about, this is a really deep conversation, but
we could do a whole legal brief on it, because I agree with you.
We could do a whole podcast on it.
Here is what I think. In my first decade after I graduated, it opened doors for me that I don't think I deserved, just because I had a diploma from there. And I'm really appreciative. Now, it was up to me, obviously, once the doors were open, that I did something with it. And I'd like to think I did. But it felt a little unfair because I don't think I deserved those open doors. So I'm very grateful that it allowed me to basically go anywhere, go to any jurisdiction and be able to have my dream job there. And I really appreciate that. But in terms of seeing a lot of people around me sell their souls, sell their cars, sell their houses, go into incredible amounts of debt, and their entire community is trying to support them to be able to get this degree, and the amount of sacrifice that comes with it, whether that's worth it, I have counseled a lot of people away from taking on that amount of sacrifice when, say, another school is offering them a full ride. And what they really want to do is to practice law, and to not be saddled with 6 figures of debt is no small thing. It affects the rest of your life. It really does. It affects when you get married, because you can't help but think about it. It affects, paying for houses, buying houses, being able to provide for kids if you ever have kids. I mean, these are really life-changing decisions. And so part of it is, all you ever hear out there is there's nothing better than Harvard and Yale. This is just a realistic view, especially if you come from somewhere where I don't come from deep pockets. I don't have a trust fund. I don't have parents who understand the Ivy Leagues. And I went because I truly thought it was interesting, which sometimes is not enough. If you want to go in so you can make a lot of money, maybe it helps to go to a name brand school. But that is a huge life decision to tell someone, maybe in their early 20s to make. So hopefully this at least gives you the idea that there's more than one side of that discussion to be had.
That was a deep question, so we're going to end with a lighter question. This is from Jilly Bean.
I don't think that was the question at all.
And it wasn't, but we just went crazy. Okay, Jilly Bean, which is a great name. And you got to answer this one first, because I got to think about this. If you could be any movie star, who would you be and why?
Oh, I know the answer.
Oh, there we go. It's perfect. Okay,
I'm not going to go with historic, because there's actually amazing, for example, Lucille Ball is my favorite actress of all time. But we're not going to go there. I'm going to go with who I think of right now and who I saw on a reel today. Jennifer Garner. She's hilarious. Have you seen her Not a Cooking Show videos? They make me laugh so hard. And she just seems so wonderful. And she's like wildly successful, but also like incredibly real. And she just seems like she really enjoys her life despite having massive amounts of fame. And it doesn't seem to have impacted her in a way that a lot of other movie stars do. So just because of her life and her really Not a Cooking Show series that she makes make me laugh so much. And I do like her movies. She's adorable and tough. Don't forget Alias.
Not a huge Jennifer Garner fan, but that's
she's awesome, right? She's just like happy. She's so great.
You would be an amazing Jennifer Garner.
Thank
you could own a farm. That's what I'm told, based on her Capital One card.
That's right.
She owns a farm.
She does a lot of commercials. Now that you say that,
I'm gonna go with Idina Menzel because
I love Idina.
Because I just really
you want to be
on
the ice
Broadway.
queen?
I just want to sing on Broadway, and I love "Let It Go." It's amazing. It's a great song. You know, I sing it with my kids all the time. So I'm gonna go with that. I'm gonna go with that.
The only thing with her, I don't disagree with you. You know, she was like my first love. We've talked about this in our Broadway, in terms of when I saw her, I wept like a child. Went to the bathroom and like dry heaved because I was crying so much after she finished singing "Defying Gravity." But like when you say movie star, she has been in movies. I loved her in Enchanted.
She was in Frozen.
That's fair. That's fair. Which
Look,
came
the
from
only
her
movies I
wonderful
watch
singing.
now are children's movies. Okay, I don't want to. I don't want to hear anything.
Well, my kids don't watch TV, so that one day I will watch children's movies. I can't wait.
I feel like if I could sing like her, I could be in Les Mis.
Anything.
And that's my ultimate goal, is to be in Les Mis. I just want to be.
She doesn't actually have a voice for Les Mis. I'm just gonna put it out there.
What was that?
She doesn't have the like voice actually from Les Mis. She's perfect for like Rent because she has a gritty voice. I love her voice, by the way.
You don't think there are gritty people in Les Mis? I mean, what are you talking about?
No,
We're
it's
talking
a different way.
We're coming up from the gutter
singing
here.
Okay. Well, now we're just getting into a fight, and I'm pretty sure my other child has run out the front door. But whatever. These are fun questions. Thanks for all the hundreds of people who've stayed to listen to this.
I know, just to listen to us.
I told you I had a deadline tonight.
Anyways, sorry about that.
Wait, whatever. I mean, who needs sleep?
It's 10:30.
Get done.
Yeah. Okay.
The good thing about having a deadline is most people, what do you have? What's it? Sleep. And so when they sleep, I work.
There you go.
Okay, I should sign us off.
I forgot you were trying to get out of here.
This has been an awesome discussion. Sorry it's gone on so long, but you know what? When you ask us to react in real time, we will do so, but not with brevity. And with that, please let us know if you have any thoughts, comments. You can reach out to us at prosecutorspod@gmail.com. Reach out to us on X, Twitter, Facebook, Instagram at prosecutorspod. We love hearing from you. And until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
Anyways, so I had this like crazy. Today was a really busy day, so I'm glad to be with you guys, drinking bourbon. You know, this is when bourbon tastes especially good. You sound the same, Brett. Oh, that hurts my feelings, Lillian. But it would be Lillian who would hurt my feelings because that's what she does, just constantly.